I can't tell. Okay, we've got everybody. All right, Mr. Bowen, I think you're up.
Yes, thank you, Your Honor. This is a case that is not difficult, but was made very difficult. What happened is that the corporation, Anderson Corp., had or bought a piece of property in Pinellas County. In 2004, one of the 0.5 owner and vice president transferred the property to George Anderson, and then transferred the property from George Anderson to that individual, Tara. So the key question, I guess, is that my client is claiming, both of them, is that there is at least one forged deed that was between Anderson, George Anderson, and Otera. And that forged deed the evidence shows that that was a forged deed, and that the motion to dismiss or the motion for a directed verdict was improper. That's essentially the first part. The second part is that there was a defense that
before you run on to the second part, let me just confirm that there was no dispute that Anderson testified the deed out to Otero was forged.
That is correct.
Because then you have Otero conveying it in the throes of a bankruptcy proceeding to
Miller Bay.
And that deed ostensibly on its face appears valid. But if the deed is forged from Anderson to Otero, that's a wild deed, and that vitiates anything that comes after that. You can't convey property after you acquired it by a forged deed. Is that true or false?
That is the position that we have, and there was no evidence to indicate, except for the deed itself, that there was not a forgery.
The trial court didn't reject Anderson's testimony as a hoax or a fraud on the court or false. The court basically went off on some sort of a analysis that, hey, this deed is valid on its face, therefore it's good. I don't care about the consideration. You lose, directed verdict for the defendant. Is that?
Yes, sir.
Fair. Okay, you proceed.
Okay. The other thing, and I would, by the way, like to reserve 5 minutes in rebuttal.
Sure.
The next issue, argument 2, that is the bankruptcy. And we had indicated at the very beginning in 2016, when the first complaint had been filed, that there was a bankruptcy. So I'm not sure how you could claim that you didn't know about anything. They should have intervened.
There's a question there, because generally when you take property without a warranty deed, you would take it by a quitclaim deed. This was by a special warranty deed, but nobody really warranted title because the bankruptcy was public record. Is that correct?
Yes.
So do you know why they termed this a special warranty deed? And
No.
The title company that was listed as preparing it denied all knowledge of the parties or the record and didn't do this.
That's correct.
They confirmed it was a forgery, essentially.
Yes.
And the judge didn't reject that testimony either.
No.
Okay.
The one place that I thought might be interesting to you would be that the issue of the distribution or the dismissal by the state for the corporation, and whether the corporation could sue under that particular status for the case that we have. And I know, Judge Valente, you had actually authored the trans health case, and I know Judge Northcutt, who had done the Hawk case, which is just recent, and I think you've even done the BBK case. But in any case, I think the Hawk case is very clear that, in essence, we have to, we can continue the case. We can continue to pursue the property in winding down the corporation. We started off in 2004. We went from, we started in 2009 when we filed the suit for quiet title. That was against Otera. Then Otera files bankruptcy. We had an adverse action in the bankruptcy case. And then we had, when Otera gave it away to Miller Bay, and there was a discharge in the bankruptcy, there was no reason for us to pursue that case in circuit court because I couldn't collect any money from her and she didn't supposedly own the property. So
the bankruptcy trustee did assign the claim of the property in 2019 to
correct.
Anderson.
Yes.
Okay, not to Miller Bay, who claims they got it in 2015.
They claim it in that the deed was in 2015. We didn't find out about that deed until sometime in 2016, and we immediately filed. I think it was in June of 2016.
And there's no dispute that Anderson was paying the taxes, maintaining it, and doing whatever an owner normally does to the property before and after Miller Bay received that special warranty deed.
Before, yes. After, I don't think my client paid the taxes after it went into bankruptcy and there was an adversary proceeding.
Okay.
But he paid it from 2004, which was the date of the deed, all the way through 2011.
So we don't know the status of who paid the taxes after 2011. Is that what you're saying?
No, I know, but I mean, that wasn't an issue in the
Okay.
case.
I understand. All right, go ahead.
Anyway, so then the third argument we already talked about. The fourth argument is the fact that Mr. Miller is well known and has a plan that he takes property from people under very strange circumstances, sometimes even forging their names, and to obtain property, and then sells it at an inflated price. Those are the facts.
Just before you leave that point, does the record reflect he paid $20,000 for this property and was worth 5 to 10 times more than that?
The only thing that was out there was his testimony that he paid $20,000. Now that is against his admission, judicial admission that was made in the answer. And also, if you look at the deed itself, it says that it was for minimal value, and the doc stamp showed that it was for minimal value.
For $100 or something like that. Okay, I got you.
So anyways, I think it was relevant to the court, or relevant to the case, that these acts that we put in and proffered at the end of the case reflects on whether or not he is a bona fide purchaser for value. I'm not sure we have to even reach that point, because bona fide purchaser for value is not a defense to a forgery. It is a defense to a fraud. And if you'll notice, there's a lot of talk in the appellee's brief about it being a fraud. We didn't sue in fraud. We sued in forgery. That's about all I get.
And a lot of the evidence put in was not certified copies, but there was no objection. They were all received in evidence?
Yes, the deeds were all received in evidence.
All right, thank you.
That's
About it.
All right, thank you.
Thank you, Mr. Bowen. Ms. Widener. Mr. Widener.
Please, the court, your honors, counsel. Your honors, I would just like to rely upon the arguments as included in the briefs and allow the court to make its disposition thereof. Thank you.
Thank you very much. I want to just
And I-
commend you for what you said, by the way. That was a pretty good position to take in light of the record.
Thank you, Your Honor.
And I have no rebuttal, obviously.
All right. Well, thank you
Okay.
for that position.
Thank you
All
very
right,
much.
That concludes our docket for today. We're adjourned. When you guys leave, the way you do it is there's a leave button in the lower right corner of your Zoom screen. If you click that, you're out of here.
Thank you.
Thank
Thank you
you. Thank
both.
you all.
We're adjourned.